Okay, so very warm welcome to all. Thank you for being here this evening. We have the pleasure of welcoming at the University of Louvain, in the context of the Global College of Law, Professor Katharina Pistor. And of course, Katharina has a very long and impressive CV, which I will briefly refer to in introducing her to this audience tonight and explaining how we are going to spend the next 2 hours. We will interrupt the discussion at 8:30 sharp. But I think I would prefer to start not by describing the CV of Katharina, but by saying that she does not mind having no glass with which to drink, and that she is a very powerful defender of academic freedom and freedom of expression in university settings. And she is a colleague whose friendship I cherish very much. We published together a few years ago this book, Governing Access to Essential Resources. I shared part of the credit, but all the work was done by Katharina very generously. Today, we have the pleasure of welcoming Katharina because her book, The Code of Capital, How Law Creates Wealth and Inequality, that was presented as one of the best books of the year by the Financial Times in 2019, has been published in French, not recently, but a few months ago. And we thought it important that her ideas could be shared more widely within Francophone Europe, including in this university. Katharina teaches comparative law and jurisprudence at Columbia Law School since 2001. She is director of the Center on Global Legal Transformation and a member, I think, still of the Institute for New Economic Thinking, which was founded in 2009 to provide alternatives to mainstream economics in the aftermath of the great financial crisis. Joseph Stiglitz and others are part of this Institute for New Economic Thinking that is really a laboratory for new ideas that has been developed at Columbia University. Katharina has been awarded many prizes, including the most prestigious scientific prize in Germany, the Max Planck Research Award in 2012. And it is therefore a great pleasure and indeed an honor to have her present her ideas this evening. Now, the work of Katharina, as presented in the book that she will discuss this evening, is at the intersection of three scholarly traditions. First, there is a very vibrant tradition of institutional economics. And we discussed, I say we, the students of this class of mine in legal theory, we discussed the work of John Commons, and you may recall when we discussed the legal foundations of capitalism, a most important book of 1924 that John Commons published at the time when he was essentially building the premises of a welfare state in the state of Wisconsin as an advisor to the Republican governor La Follette. And as you also may recall from the class we had on this, it is what was attempted in Wisconsin that later served as a sort of blueprint for the New Deal of Franklin Delano Roosevelt. John Commons is one of the most remarkable figures in institutionalism, and he was not, of course, the only one. He was followed by many members of the school of American legal realism, including Robert Lee Hale, whom we also mentioned in our class. A particular reference was made to the book Freedom Through Law, published in 1952 at the end of the career of Robert Lee Hale, in which Hale was discussing coercion in a market society, showing how contracts were never entirely free and how coercion was inevitably interlinked with freedom in the negotiation of contracts. Hale described the market economy as the Macht economy, the economy of power, and he, together with others, brought power relationships in the description of market relationships, alerting us to the dangers of private government being exercised through markets that states should pay greater attention to. The role of the law in shaping capitalism and in legitimizing relationships in the markets that lead to wealth concentration and inequality dates from that period. It has been documented also by a legal historian such as Harold Berman in Law and Revolution, the Formation of Western Legal Tradition. That is one of the books also that the Code of Capital refers to. So that is the first tradition. The second tradition is what might be called the political economy approach to the functioning of the state. And here again, in the course we have on legal theory, I refer to this as being the Machiavellian tradition, because actually when Nicolas Machiavelli advises Laurent de Médicis as to how to retain power, despite proclaiming to work for the interests of the people, he actually unveils the reality of power relationships and the competition for influence by the factions that try to capture the state to serve their interests. And in the progressive era in the United States, a historian such as James Byrd, who published an economic interpretation of the Constitution in 1913, also tries to highlight the dangers of idealizing the state and not seeing the power relationships behind how the framing documents, the Constitution in particular, were negotiated and later interpreted by courts to justify the maintenance of the capitalist legal order. Now, this tradition has been exemplified in more recent years by people like Robert Reich, the former Secretary of Labor of President Bill Clinton, by Joseph Stiglitz, particularly in the book The Price of Inequality, or by Luigi Zingales, an Italian-born economist who coined the term the vicious cycle of the Medici to describe the fact that increasingly today money is used to influence politics, and politics are used in order to make more money in creating a rent-seeking kind of government, allowing the most powerful economic actors to basically ensure that the state will further allow them to reinforce their influence. So that's the second tradition. And then there's a third tradition, which is the theme of the disembeddedness of economic relationships vis-à-vis society. And that is the theme. We have not discussed this in this course, but it is a theme that was most explicitly and visibly put forward by Karl Polanyi in a book he published in 1944, The Great Transformation, which I only briefly referred to, and in later studies of Karl Polanyi on markets in ancient empires. And what Polanyi tries to show is that the originality of trade as a means of satisfying social needs is what stands out in the modern era, but more particularly, he shows that competitive market exchanges result in a situation in which the prices are set based on supply and demand rather than based on social traditions. What normally has been paid for a particular good or a particular service in a market society that is developing in the 1930s, for example, the period which Polanyi was most interested in. It is not based on social norms or traditions that prices are set. It is based simply on supply and demand. And land, labor, money itself become fictitious commodities. They are not produced for exchange, but they are treated as if they were commodities, leading to these goods, labor, land, and money to be subject to speculative exchanges. And so this is, or these are the traditions rather at the intersection of which Katharina Pistor has developed her work. But her work is deeply original in two ways. First, she recovers these traditions in the context of hyper-globalization, to borrow a phrase that is often used by Dan Roderick, someone whom Katharina knows well from Harvard University. And in hyper-globalization, the loosening of controls on the movement of goods, capital, and services lead to disempower the state, relegating the state to a facilitator of a process on which it has lost its ability to exercise any form of control. And actually, in the questions we will have later for Katharina, one question from me will be whether the state is responsible for what we are witnessing, since after all, the state legitimizes how property rights have developed and are now enforced, or is the state simply the passive recipient of evolutions that he has, or that it has, the state become unable to exercise any form of control on. And the second original contribution of Katharina, of course, is to identify the coding of capital at the heart of contemporary capitalism. And by this, she means that assets such as land, knowledge, company shares become tradable and can be speculated upon thanks to the protection afforded by property rights. This is a theme that someone like Hernando de Soto saw as a very positive development. Hernando de Soto premised his idea that development could be encouraged in the global south by bringing dead capital into life, by titling immovable property to allow people to use immovable property, their land, their houses, as a collateral to buy credit in order to start a micro-enterprise and so on. And in the 2000s, the period 2000-2010, that was a very fashionable way of seeing development as depending on the right institutions. And maybe the recent Nobel Prize awardees, Darren Acemoglu and John Robinson, have further perpetuated this idea. But what Katharina shows is the very perverse impacts of this, and the fact that this has become a system outside of control that is leading to extremely perverse consequences. So that is what I wanted to say by way of introduction. We will proceed tonight in 3 steps. First, Katharina will present in a very compact format the main themes of her book, The Code of Capital. We then will have reactions from Pascal Viel, Julie Ringelheim, Stéphanie Franck, Pierre Dargent, who joined us. Thank you so much. Peter Augustin, no, not tonight, but Peter Augustin, Van Mallegem, and Lise Thibony are there to enjoy the exchange, and they will have Katharina as a guest in a European law seminar tomorrow. And that's correct, right? It's tomorrow. It's tomorrow morning. And then we will have, after those reactions, we have a short response from Katharina, and then we'll have an exchange with you. I received from you, the students, a number of questions. I could not acknowledge receipt for each individual question I received. I'm sorry for this. I did acknowledge receipt to some of you. And I will, later tonight, I will highlight some of the most interesting remarks, questions I received from the students, and I will provide them with the opportunity to raise these questions themselves. Thank you so much, and Katharina, we look forward to your introduction.
Thank you. Thank you, Olivier, for this warm welcome, and thank you for inviting me to the University of Louvain. It's my first time here, and I'm delighted to be here and to be speaking to you tonight. I didn't bring PowerPoints because I feel this is always like a little bit like a canned product, and I like to have like freshly produced meals. I favor them over the canned stuff. So I hope I can basically convey the core message of the Code of Capital to you by speaking freely. I just want to add that the paperback version in French just came out, just really last month. So there's a cheaper version if you are inclined to buy it, but there's also lots of stuff on the internet already, so you might not have to do this. So the core idea of the Code of Capital, and I have to say, I was, of course, aware of the traditions that you laid out, and I feel myself being part of these traditions, but I approached the Code of Capital from a slightly different perspective. I approached it not first from theory, but inductively from what I observed. And I started looking at the system that I then sort of tried to dissect, almost like a doctor that does an autopsy after a patient has died. After the financial crisis of 2008, I was just trying to understand with a group of other scholars, first of all, what happened? And second of all, why didn't the theories that were out there in either economy or sociology predict a crisis? Not the timing, we can't ever predict the timing of a crisis, but we should know that a system is fragile, volatile, and that it might be reaching the abyss. And I started doing a research project with INET, the Institute for New Economic Thinking, a group of interdisciplinary scholars, and we tried to unpack different parts of the financial system, the sovereign debt, money, derivatives, of course, and consumer credits. And we used existing theories to try to understand when these theories failed to explain what actually happened in the real world. So I basically used empirical analysis, empirical institutional structures to reflect on the theories that we had in economics and in sociology, and then started to rebuild a new theory. So it was basically a deconstruction of existing thought and a reconstruction, and that reconstruction basically left me in the arms of the John Commons and the Polanis, etc. But we did this in an inductive process, and what came out of that was a paper which I published in 2013 in a special issue where the other projects were also published, which I called A Legal Theory of Finance. And the legal theory of finance tries to explain the global financial system. And what we discovered in our approach was that global financial system can actually be explained through the law. It's not just finance. Finance is the law. Every financial asset is an IOU. Basically, I owe you something that has some contractual structures and commitments that can be enforced. If they were not enforceable, nobody would buy that. And when you unpack the most complex derivatives that crashed in 2008, securitized mortgages, the derivatives thereof, collateral debt obligations, all these acronyms that you hear about and nobody understands, if you try to unpack them, what do you find? You find, of course, contract law. You find property, collateral law, the common law trust. You find exemptions from bankruptcy, and of course, you find corporate law. And so after I had written that paper, I just felt I want to understand what these institutions did before. Before they created this new shadow banking system, which is basically using all these devices to create banking practices outside existing bank organizations. I wanted to understand the genesis of these institutions and how they were used in the past. And that research led me to the Code of Capital, because what I found was that the same institutions that we use to explain the structure of the complex financial system that we have today, you can trace them back centuries. Some, of course, much longer, contract and property law all the way to the Romans, but the trust, the common law trust, in its modern form, maybe to the 16th century. But even property rights in land had to be rediscovered in England and in the continent after feudalism in a new way. So I basically then started telling the story about these institutions, how they evolved. And then it occurred to me that actually these institutions have been used to code the most important sources of wealth over several centuries. So until the end of the 19th century, as the data of Thomas Piketty and his researchers have shown, until the end of the 19th century, rural land in agricultural setting, was the most important source of wealth still in England. So even at the cusp of the process of, or the height of industrialization, rural land was still the most important source of wealth. That changed with a major depression in agriculture, which was accompanied by a really important legal change that actually made the life tenants responsible for the credits and the collateral that they had built on their land. And after that, you can see that land was no longer the most important source of wealth, but financial assets really became the most important source of wealth. So I decided to tell the story through examples, and I wanted to write the book not just for the experts, but mostly also for people who don't know much about the law, don't really understand the system. I wanted to unpack what I always think of as like the machine of capitalism and make it more accessible. So I have a couple of examples in the book, but I will give you basically the basic tools that I developed up front. So I'm basically saying what the Code of Capital does, and the code is a legal code, but I'll say a few words about this in a second. But what the Code of Capital does, it can transform any object, let's say a piece of land, any promise to future payment, or any idea into a wealth-generating asset if you code it in the right way. So if you just take a piece of land, it's just a piece of dirt. You can graze your cattle, you can harvest some fruit, you can grow some crops, but you can't monetize it. Nobody's going to pay you anything for it, unless you have title, unless you can show that you have a right to it. So land as such is not real estate. You have to transform it into something else through the law. You have to give it a different DNA, if you want, to make it actually a capital asset. That's the whole idea. So give me any object, idea, promise, with the right legal coding, I transform it into a capital asset in a wealth-generating and wealth-protecting asset. So I can show this for land. You go back and you do what Marx already had done, of course, and many others had done before. You look at the enclosure movement in England. There's a lot of more recent historical research that has shown that the enclosure of land, basically pushing the commoners off the land and giving clear title to the landlords, started already in the late 15th, early 16th century. The big legislation where the rest of the land was then basically declared to be either property rights or property of the state or could be privatized, that happened only in the 17th or 18th century, and that was at the tail end of a long process by which the landlords, who had for centuries shared the lands with the commoners, decided that they could make more money by not allowing the commoners to use the land anymore. So they built fences and they built hedges, and the commoners said, you know, what are you doing? They broke the hedges, they broke the fences, they plowed over the crops that they had planted. So there was physical violence really over who had the right to use the land at a certain point in time. In the end, these disputes were solved in the courts. So both sides went to the courts, and not the landlords did not all the time win, and sometimes it went back and forth and back and forth. But over the long run, over a course of 150 years, the landlords basically were told that they had the better right over the commoners because they had been there before. They claimed seniority because they had been there before and argued that we just granted the commoners a right to use the land, but we are the true owners. They got the title. And what the title allowed them to do is either sell the land, but that wasn't the most important thing for them at that time. It was actually to collateralize the land, to use the land to, as basically to get credit and offer a security interest, a mortgage to their creditors, thereby monetize the land. So in the end, producing a capital asset is always trying to monetize it to basically create future expectations of cash flows and to be able to use this now. Because if you can get a credit now, you can invest it in a commercial enterprise. You have the land that backs it up. And you already can basically have the cake and eat it too, as we say in the US, basically having the land still and using the land and having people to toil the soil for you, but at the same time using future expected returns to invest in other enterprises. So this is just one example. I'm just going to give you now what I call basically the modules of the Code of Capital and the attributes of capital that are critical. The attributes are characteristics of capitalist type of interest or interest of capital, and they are first priority. You must have better rights over others to be able to make sure that you get everything, right? You have stronger rights. And property rights is the most important right in private law, that you have stronger rights than others. And you can realize this against anybody else. Sometimes you make contractual concessions and you have to live by that, or you might have a creditor that will ask to get some of your assets to pay back the loan. But in principle, the property rights is the strongest right. So having priority is critical. The second one is what I call durability. That is the ability to protect some assets against too many creditors. That is done typically by the trust or by a corporate veil that separates assets from others. And so not only the immediate creditors have access to these assets and nobody else can touch them. That serves kind of like an incubator. So if you have assets behind a veil, they can basically prosper and grow over time without too many people trying to put their hands on it. So it's durability. The third one is convertibility, and that's actually the way in which financial assets gain something like durability. So financial assets, you don't want to hold them all the time because they can lose value. What you want to have for financial assets, you want to have an option to flip them, to swap them into a safer asset. So in times of financial crisis, I'm sure you have heard this, everybody's running to the exit. All investors want to run to the exit, sell their assets, and what do they want to have in return? Cash, state-issued money. Because privately issued financial assets lose their value in times of crisis, whereas state-issued money retains at least its nominal value. Sometimes it loses its real value, that's when we have inflation, but the state stands behind a currency and therefore can protect its nominal value, and that's worth a lot in times of crisis. And this is why everybody wants to have cash in times of crisis. If I have a right to get cash, I have something that I call convertibility. And I might have this right vis-a-vis another private actor, or I might have this right vis-a-vis the central bank, or I create something like a put option that the central bank cannot resist. I basically blackmail the central bank, says, if you don't bail me out, I'll crash the system. Right? That's another way of creating convertibility, but it's not directly illegal, but it's a de facto way in which you can create it. And the fourth attribute of capital is what I call universality. The things that we have created in law, priority, durability, convertibility, will be enforced not only among the parties to the contract, but very often also against third parties. So property rights have to be accepted by everybody, whether or not they knew about it. You just hold up your title and said, you're trespassing, leave my property, and I can get the state to actually protect my rights. So these are the attributes, and then I'm basically looking at sort of what are the legal institutions that have been used most often to create capital and to create these and to graft these attributes on different types of assets. So I think what the power of the code is really that it can be land one day, it can be a firm another day, it can be debt, it can be your data, it can be all kinds of different things, it can be an idea, an invention, and when you take apart how the legal protections work, it's almost always the same thing. It's always about priority. It's always about either durability or convertibility. It's always about universality. So these are basically my analytical tools to take apart the system and show you how it worked. So I told you already a story about land, the enclosure movement. I have a counter story in the book, which is also really interesting to think through. I started the chapter on land really with a decision by the Supreme Court of Belize, which after years and years and years and years of battle, recognized the collective use rights of indigenous peoples in Belize, the Maya, as property under the Constitution. So that then raises, of course, the fascinating question, what actually is property and who defines what property is? And what they ruled in 2007 in a Supreme Court decision is that, well, the Constitution of Belize doesn't really say what is property. Most constitutions don't. Most just say property is protected, and that probably assumes that the property that exists at the time the Constitution is made is protected, but it doesn't tell you. Some constitutions, like Germany's, my home country, says that property, the scope and contents of property will be defined by the legislator, but few constitutions do that. So what is property is always assumed but not defined. So then the Constitutional Court says, well, are use rights property? Then have never been registered in the formal registries, but is that the only thing to establish property? Are there other ways to establish it? The Constitution also had a lot of references to the plurality of people living in Belize, to the importance of having indigenous people and different cultures and different ways of living. And they also had a property law that, again, endorsed the idea of a plurality of property rights. And from all these different sources, the Supreme Court came out and said, if you can show, and the Maya were able to show that you have used these practices for centuries, and that's part of your way of living, we call this property. Now, in the end, it didn't help the Maya so much, because the government of Belize actually had used basically their claim to that property. They argued, actually, the British, when they conquered Belize, they changed not only territory, basically they didn't only conquer a territory, but they also changed the property rights regime, and therefore the government of Belize owns the property rights, and therefore they can write licenses for foreign investors to get the natural resources out of the ground. And the government of Belize basically lost the lawsuit, but chose to ignore it by and large and continued the licensing practice. Which tells you also that even though we might actually have a much more encompassing idea of property rights, in the end, the kinds of rights that will stand and will be protected are the rights that are backed by the state. Without that, you don't have these rights. So this is land, and then I talk about firms. I'm not going to unpack all the stories, but I just want to give you a little bit of a flavor of the book. When I talk about firms, of course, I talk about the corporation, a particular legal structure that was invented in the early 17th century. It is, of course, the core institution of capitalism today. It's the way in which we can maximize returns for the shareholders, and it also shows you how property rights have changed their meaning from having use rights to land or use rights to objects to really creating expectations to future returns. And John Commons talks about that as well. So the idea that property rights is actually about having something, controlling an object and using it is kind of old-fashioned. Most of the wealth today is in financial assets or maybe intellectual property rights. It's all intangible. It's all made in law. It doesn't exist outside the law. So you can show this for corporations, you can show this for debt instruments. I unpack the entire story of securitization and how we use different institutions, the trust, property rights, collateral law, all the stuff that we've seen already in the coding of land. We use this to basically turn debt into capital assets that you can hold and on which you can make a lot of money. Then maybe the one story I wanted to explain a little further, because it's, I think it's sort of a good story to tell, is about intellectual property rights. And the story I used there was Angelina Jolie, an actress you might all be familiar with. She had a double mastectomy in 2013, I think it was, and she wrote an op-ed about this in the New York Times. And she said her mother had died of breast cancer very early, and she feared that she might be a carrier of a gene, the BRCA breast cancer gene, that might cause cancer. And if you get it, this is almost your death sentence. It's very hard to fight that particular breast cancer disease. And so she had herself tested, and she had the disease, and so she decided to do a mastectomy. And then wrote about the fact that she had to pay $3,000 for the test. But that there was a court case pending at the US Supreme Court because doctors and families and patients were challenging the fact that a little company had claimed a patent over the BRCA breast cancer gene. And so in June of 2013, the US Supreme Court actually struck down that patent, but that was 2013. The patent had been granted in 1994, and it kind of just stepped over fundamental principles of intellectual property rights that most people had believed in a long time, that certain things are not patentable. Things of the common human culture are not patentable. Algorithms that everybody knows are not patentable. Of course, the human genome cannot be patentable. Kind of crazy to think that somebody could patent the human genome and prevent others from using it, and tests that were built around, they were basically trying to understand the sequence of the gene. So I should just step back a little bit. A group of scientists funded by public money had discovered the gene. After the discovery, you still have to find the sequence. You have to know exactly the basis, how they string along to understand where the defect is. So the sequencing was where the race between, again, publicly funded researchers and private venture capital funded researchers started, and the private ones won. They found the sequence first, and they went to the patent office in the United States, and they got a patent. Now, it was struck down, but from 1994 to 2013, they made a ton of money because they sent cease and desist orders to every doctor in the country who used their own tests that they had developed after the sequence had been known to test women for $200. But they wanted, of course, the $3,000 for themselves. And not only did they want to have the fees, they wanted to have the data. So with the help of the patent, they built the largest database for breast cancer in the country, and in 2004 already they started sharing it with anybody else. So they used the patent, which is a monopoly in a way, to create another monopoly for data, and that also helped them actually make a lot of money even after the patent had been struck down. So what the story tells you is that, of course, intellectual property rights they're really made in law. Nobody can debate that. When people think of land, they always think it's property. I'm trying to say it's actually there's land, and then you have to create property rights to make it a capital asset. For intellectual property, it's very clear, and even though also the United States doesn't really tell you what property is and who makes property and creates it, but for intellectual property rights, the Constitution says the Congress has the power to make copyright laws, to enact copyright laws or patent laws, right? So it's absolutely clear that intellectual property rights exist only in the law. And then the question is, how can people use those features of the law to create capital assets? And the story of the BRCA breast cancer gene is just one. You get a lot of money, you're a little faster than anybody else. You are able to convince the patent office that somehow there was human ingenuity involved. It's just not only nature. You patent it, you run with it. And then you wait for the others to strike it down. It's also very important lessons from the Code of Capital is that when we talk about the area of private law writ large, the law is actually a resource that can be relatively freely used by people to organize their own legal relations, to code their own capital, and if somebody doesn't like it, they have to challenge you. In other words, you have a very strong first mover advantage. If you go out and you create new financial assets, if you claim patent for something that, even if it might be struck down in a couple of years, you still have that monopoly for those years to do something. You have to have somebody who is going to fight back and challenge your rights. And so you can exploit, at least for a time, the rights that you've had. And sometimes nobody challenges you, and you just basically, based on legal opinions of your lawyers, you say, it was legal after all. So I want to talk, so what I'm saying basically in the book, I have different stories about how capital was coded over time for different types of assets. It's always the same mechanism, always the same process. And what I really mean by the coding of capital, I think you understand this now, I'm not talking about codification. So it's not like the Code Civil or something like that. It's not a codification. It's the process of using features of existing law, typically private law, that you graft on, that you combine with different types of asset. It can be land, it can be debt, it can be firms, it can be data, it can be ideas, it can be virtually anything, if you push it to the limits. So I want to talk about three more things, if I may, if I have a few more minutes. I want to talk about the masters of the code, the lawyers. I want to talk about globalization, and I want to talk about what all this means for democracy. And I'll try to be short. So the question, of course, always when you tell kind of a detective story like this, and you see like capital is made, who's done it? Who's made that capital? And I'm saying these are the attorneys. The lawyers make capital. The lawyers know the code. They make capital for their best paying clients, and they've always done that. So when you go back to the enclosure movement, the question is, who wins a court battle back then, right? First is, who has even standing in a court of law? Typically individuals. Collectives have a much harder time to make a case. And so many cases were already turned away by the courts back then because the commoners came as a group, whereas the landlords came as individuals. The second was it was a written procedures, and the commoners might not have been literate. Very, very often they were not. They needed a law clerk at the court to write down their complaints, so that sort of shifts the balance already. And then you have to ask, who are the attorneys and also who are the judges sitting there? They're typically coming from the gentry, from the they're coming from the aristocracy as well, from families where we have primogeniture as the inheritance right, so the firstborn son gets everything, the secondborn son has to find a different profession. It's either accountancy, law, or medicine, or maybe clergy. And that's basically how you get a sociological explanation for the bias that is implicit in many of these rulings. I'm focusing mostly today on attorneys that are working in major law firms and that have, the liberty and, of course, the skills to find ways to create new types of assets for their clients, even if there's regulation in place that is trying to push back. So for many years, I taught a class on law and finance with a practitioner, with an attorney who has done all kinds of securitization in her life. And she explained to my students always, when you want to create a new asset, you have to think about the existing rules and regulations in your own country, but perhaps also in other countries, as the scaffolding around a building, right? So you look at all these rules and regulations. If you want to create something new, it has to fit through the gaps of the scaffolding, because if it hits the scaffold, it's void. It's legally unenforceable. It has to be legally enforceable, because otherwise you can't really sell it for money on the market. So you have to design something that is compliant with existing formal rules, not necessarily with the purpose, but certainly with the formal rules, so that it's legally valid. It has to be legally valid, otherwise it won't work. And so you find all kinds of ways to arbitrage around existing rules and to use the letter of the law to find ways to create new assets, even if it violates the purpose. For that, again, you have the first mover advantage. Let somebody come and challenge what you're doing. If you're big enough and fast enough, you can produce a lot of capital before anybody challenges you. And for you, the 2008 crisis already is such a long time ago, but when you look back to the 2008 crisis, when finally all these assets that had been created for 30 years became toxic, most of the lawyers I spoke to at the time said they didn't know what happened. They had worked with the smartest people in the world. They had solved the most complex legal problems, and whoa, now the entire system blows up around them. And so one of the reasons I want to write this book is to say, actually you are in the game. You're doing it, but of course you are doing this just for your client. You never think about the system. You're just trying to find a way around these rules and regulations to have the best outcome for your client, but you're not thinking about what happens actually if we have all these derivatives that want to be turned into money at some point, because when there's a run, everybody wants to have money, and money is not sufficient to fulfill all of these claims. So it's basically the masters of the codes are the attorneys. They're doing this in their offices. They can do this because private law is malleable, it's available, you can change it, you can recombine it in all kinds of different ways. That's how they make money. When you look at the fees that big lawyers are making, it's getting very close to what investment bankers make, and that tells you what the value of law is in these kind of transactions. So that's story number one. The lawyers have done it and are still doing it. Second story I wanted to tell is about globalization. So very often globalization is described as a world in which there is no state. You just move out of the state sphere and you do something in the global space and you're free and you can do all kinds of things. And I basically say that's rubbish, because if you want to do something that really is monetizable, where you really make money and you can protect your own interest, it's got to be enforceable by some law, by some court of law in some country. And it's not just any law in any country. When you look at the legal systems that are used to code most of the tradable financial assets in the world, there are the UK and New York, or we can say UK and US. So when you look at London and New York and you see the global financial centers, they're still at the peak of the most important global financial centers. They're also the most important global centers. So when you look at a list of law firms that have offices in more than one jurisdiction, these are the global law firms. If you look at the list of the top 100, about 98 of those of them are either English or American. So the globalization of law and the practice of globalization by way of creating the kind of assets and strategies and transactions that I was describing is happening by lawyers from primarily 2 jurisdictions. And my argument for that is that the common law is just much more accommodating to the kind of practices that I'm describing. You're much more flexible. There's much less policing of the boundary between public and private law, for example. The best example for this, of course, is the trust. There is also, when you think about the legal profession again, judges in most civil law jurisdictions become judges after law school, maybe after special training. In the common law world, you are first an attorney for several decades, and then you will be elected to the bench. So you know exactly how the other side ticks. And it's not clear that you tick so differently when you're sitting on the bench. So it's a very different approach to lawyering and judging in the two systems. So in other words, globalization is deeply legal, and it's not just like a free-for-all. It's not like a patchwork of all kinds of different legal systems, but it's very hegemonic. It's very much dominated by 2 legal systems. And of course, I and my law school, Columbia Law School, we are supporting this because every year we have about 300 LLM students who come to our shores just to Columbia, and hundreds of other students go to London or Oxford or Cambridge or to Harvard or what you name your university. They're all getting LLM degrees in the United States, and they're coming back and bringing the practices back into the practices of firms here. And of course, you've also seen many mergers between local firms, law firms here, and global law firms. So the practice has diffused into jurisdictions and in the civil law world as well. So then the final thing, democracy. How do we square all of that with democracy? And so I think here I'm already making a pitch for a follow-up book that I have submitted, but that will be published only next year, where I talk about capitalist law. And I think what we're really seeing here is the duality of 2 legal systems within one, which is public and private, which we very often debunk and say there's no real difference. And many of the legal realists in the United States have said, in the end, all law, including private law, is public because it must be enforced by a state. But the socialist legal theorist Yevgeny Pashukhanis, who worked in the 1920s in the Soviet Union, he actually remarked that you could just as well say that all law is actually private. When you trace the evolution of law back in history, it was first private, and public law emerged actually pretty late. And when it emerged, when sort of constitutions were built and later also democratic institutions came about, nobody asked questions about the private law. To the contrary, we embraced the existing private law and the property rights that existed in that law in existing constitutions by guaranteeing property without defining what they really meant, by guaranteeing the sanctity of contracts, and thereby basically enshrining a particular mode of organizing business. I think what we're seeing today is an increasing tension between the world of private law and private money and private wealth and the world of collective decision-making through public organization. So when we govern ourselves in democracies, we govern ourselves through law, not really by other things. Of course, built on informal institutions, cultures, common understandings, and there has to be a close connection between that, so for law really to stick and to be relevant. But we're currently basically having a world where many powerful actors can opt out of the legal systems that we think are one. We think it's public and private all one. But powerful actors can simply opt out of Belgian law, German law, French law, and opt into English law or New York law for most of their global transactions. They relocate their issuing entities to a venue in either London, could also be a tax paradise. They're free to do that, so they can opt in and opt out of the legal systems, while at the same time the rest is trying to govern themselves through law. And obviously, if we all started to treat the legal system as a menu from which we can pick and choose whatever we like and drop the rest, we don't really have a common understanding of a legal system anymore. We're not governing ourselves through law. So I think there's a real tension in the system, and I think the political calamities that we're finding ourselves in today, I relate very much to that kind of calamity. And with that, I'll stop. Thank you.
So now we open the second. Thank you very much, Katharina. This was super illuminating and interesting. We now will open the second sequence of this evening. Each of us, my colleagues and myself, will have a couple of questions addressed to Katharina. I think we agreed on more or less 3 minutes each. Is that correct? 5. I said 5. Anyway, we'll be concise. And Katharina, do you want something to write, or you can manage?
I have.
Okay, fantastic.
And you can turn.
And then we'll have Katharina provide a collective answer to these questions, and then we will open up more broadly. So why don't we start with you, Julie?
Okay.
Yeah.
Thank you, Olivier. Thank you, Katharina, for this brilliant presentation. In your book, you make a very compelling demonstration of the key role played by law and lawyer in sustaining the current form of capitalism and the inequality it produces. As you explain in your presentation, you show, as you recalled in your presentation, how through operation of legal coding, some assets are given legal privilege over others, and how this allows a small minority of asset holders, those who have access to the lawyers with the right skills and expertise, to capture the major part of the wealth produced. And what is especially disturbing in what you describe is that these legal operations, which profoundly impact on the distribution of wealth in society, are done by private actors in private law firms, and increasingly escape the control of democratic institutions like parliaments and courts. And this, as you said, dangerously undermine both the operation and the very legitimacy of democracy. And all this raises fundamental questions about the relation between law and democracy, between law and inequality, and also about the ethics of the legal profession. But one of the main lessons of your book is also that for all this process to work, these legal creations need the support of a state. The legal advantages that asset holders claim ultimately depend on state law and state enforcement. But the paradox is that states have become complicit in the evolution you describe by dismantling a number of legal regulations that used to constrain market actors. Yet, as you argue, capital's dependence on state law also implies that this evolution could be reversed. And in your last chapter, you give us some hope that with sufficient political will and with international coordination, democratic institutions could potentially regain control over the working of capitalism and this fundamental question for any polity, how the wealth is distributed. In this last chapter, you outline some key measures that should be taken, according to you, by state authorities to enable democratic polities to regain the power to decide collectively on these fundamental issues. So I have two questions relating to this program for reforms you call for in this last chapter. Your book was published in 2019 during Donald Trump's first mandate. That was 5 years ago. So what is your reading of what has happened since then? Have some of the measures you advocate started to be adopted or put forward either by the Biden administration or by the EU or by other states or organizations? We can also think of the OECD effort to establish a minimum corporate tax for large multinational enterprises. And related to that, I cannot not also ask with the re-election of Donald Trump, how you see the future. And my second question is about the role of civil society actors. What, according to you, could be the role of civil society actors like NGOs and trade unions in efforts to restore democratic control over such key social economic issues? And how can lawyers, at least those lawyers who are committed to the public interest, to the common good, rather than to the interest of the wealthiest, how could they contribute to such endeavors?
Thank you, Julie. We turn now, if you agree, to Stéphanie Franck.
Thank you very much. Thank you, Professor Pistor, for this enlightening presentation again, and this fantastic book, I must say. I might jump in from the field from which I come, which is conflicts of laws. So that's what I usually do, and that's what you're going to learn next year. Professor Pistor just mentioned that actually in business transactions, parties can opt in and opt out of a legal system. And that is the result of private international law rules, which you don't know yet, but basically it states that parties can actually choose the law applicable to their contract. They can also choose in front of which court they're going to litigate in case there is a problem with the contract, in case they have a controversy over the execution of the contract. So because they are apt to choose the law and the jurisdiction, they can opt out of a legal system and opt in another legal system. And you described very well how there are 4 layers to this: the ability to choose the law, the ability to choose the court, the ability also to go through international system of private litigation, that's international arbitration. And then, after all this, after parties have chosen where they're going to litigate and which law is going to be applied, they have usually the security that the decision is going to be enforced wherever, right? And this is what you describe in a way. It is part of the universality of the coding of capitalism, right? At the end of the process, the decision that they have opted in for, because they have opted for the legal system, it's going to be enforced anywhere. So this is part of the globalization system that is reinforcing the ability to code the capital, because lawyers have actually a great agency into there by choosing opting in, opting out. Well, I have a comment on that and maybe a question. Of course, legal systems, states are complicit, as Julie just mentioned, because they, on the one hand, in 2 ways. They offer the ability to execute party autonomy, to opt in, opt out. And in addition to that, they limit the limits, right? There are some limits to party autonomy, but these are more and more restrained. The more and more time passes, the limits to party autonomy are more restrained, if you want. And this is a tendency that we're going to discuss next year that is very strong in the EU. And there is one idea behind that, and that idea is a very basic idea in legal system, and that is the idea of legal certainty, right? Business needs legal certainty, needs previsibility, and in the name of legal certainty, parties can opt in, opt out of legal system and play around with the legal system to a certain extent. So the idea of legal certainty seems to be at the core of the system, at least in the EU. Well, this is really when we're going to read papers of the Commission, regulation and everything. Everything rests on legal certainty. So you mentioned among the solutions that actually we could roll back, right? We could limit party autonomy, the ability to opt in, opt out of legal systems. I'm afraid, and that would be my comment, in the EU, I tend to see the opposite lately, and especially, let's just take Belgium as a legal system. In the last 7 years, I would say, we have furthered international arbitrations with a new law. We have limited or limits to party autonomy by striking down some overriding mandatory rules. You know what that is, but these are limits to party autonomy. And we have actually now embodied in our legal system, the incorporation theory, and we have abandoned the seed theory, the real seed theory for legal companies, which we have been holding on for a while. We were the last one almost, but now that is over. So companies are encouraged to move around and incorporate wherever they want. So I do not see a clear tendency to limiting, also in the case law of the ECJ, even in the aftermath of the financial crisis. We have seen the ECJ limiting the limits, restraining the possibility of putting limits to party autonomy. Now the question would be the argument of legal certainty. I see it in your book as legal certainty backing party autonomy being an element of the codification, right? It helps lawyers to code the capital because of legal certainty, and thereby to capture resources and create new resources. Now, reading I just had in mind lately the book of David Kennedy, A World of Struggle. And he uses the argument of legal certainty in a way as well, but in another way, in saying that, well, the more there is legal uncertainty, the best it is for lawyers. So he doesn't think that legal certainty is best, that legal uncertainty is best for lawyers, because there they have a feel for struggle. And there, where there is uncertainty, they can capture resources and create struggle and participate to the struggle. I do not think that there is a contradiction there, but if you can maybe explain how these two visions of legal certainty relate. Thank you.
Thank you. We can turn to maybe you, Pierre. Is that okay? And then Pascal. But you're there. Okay.
Merci. Okay, thank you very much, Katharina, for the talk, for the book also. That was really inspiring for me. Your thesis sheds new heuristic light on my own observation in the field of social law, which is mine. I specialized in this field because I was attracted by its emancipation from private law, by the legal innovation bring about through the creation of standards through collective action, a source of great creativity, and the collective pooling of risks outside the financial market, represented by social protection. And in principle, these aspects provide the best possible protection for workers in their relationship of economic dependence and legal subordination to an employer. However, I also realized from the outset that the institutionalization of labor law and social security sometimes presented as conquest of the workers' movement, also constituted a pillar of the capitalist production system, and paradoxically contributed to the exploitation, appropriation of the human person and work. And this has always provoked in me a kind of cognitive disharmony that I have never been able to resolve. And although labor law is not central in your work, I know, but nevertheless, by exploring the fields of law and legal instruments, your work highlights the illusion of presenting a series of civil and even social rights as evidence of democratization and social justice, when in reality they are the anchor for the codification of unjust capitalist appropriation. And this enabled me to resolve the dissonance I was talking about. And for instance, you helped to understand how at the time of the abolition of slavery, by a sort of trickery, the development of labor law, which seemed to aim at the emancipation of human appropriation, in fact, codified the appropriation of human labor by a dominant minority via the employment contract. So the same people who were slaves became employed people, but their real condition didn't really change, of course. We're talking about millions of people. And this probably explains the extremely cautious and restrictive interpretation given by the ILO to the notion of forced labor, which is really restrictive, I think, in my view. And, and it also explains the fact that economic coercion is not considered as a vice of consent in the context of an employment contract. So the question I would like to ask you is twofold. The first concerns social law and is a political one. What transformations in the law would, in your opinion, make it possible to radically autonomize human labor? And the second one is more theoretical and concerns care work. And it remains somewhat in the shadow of your analysis. But capital, as Fraser, Toronto, and others have shown, was largely built on its gratuitous exploitation. How would you approach this exploitation, this appropriation of care and reproductive work, and more fundamentally even of women's bodies, through the concepts you develop in the Code of Capital? It's a bit exploratory, but I would be interested to hear some avenues of reflection on this topic. Thank you.
Thank you, Pascal. Pierre, please.
Thank you very much, Olivier. Professor Pistor, it's a pleasure to meet with you and students. Good evening, everyone. I must confess I've been a bad student because I've not read your book, and I apologize for that, but I've been binge hearing your talks on the internet about the presentation of your books, and I've learned a lot. And basically, I mean, the unpacking that you do through and that you have also presented tonight is very convincing. The basic claim, I think, that you are making, that law creates wealth, is difficult to challenge. And whether creating wealth is a bad thing as such, which I don't think you claim, is not the issue. Whether the creation of wealth necessarily results in inequalities seems to me a bit unavoidable, because by definition, wealth is a difference, therefore has inbreeded into it the notion of some form of inequality. Whether it is impossible to address and redress some of those most egregious forms of inequalities, of course, is another matter and is not excluded as such by the code you describe. And it's probably more an issue of the public law, this divide that you, traditional divide that you recall, that we know well, of which I'm not a great believer, because in reality, of course, it's all mixed up. But of course, there are responsibilities to certain actors and certain actors that we choose for ourselves or governments in that regard. Now, I think also what I believe also your work on finance, and you started with finance, is very important. I think all that, and we should not forget that, all that is also the result of some basic social and human existential needs. I mean, if you take finance, finance is an extremely interesting and powerful time machine. You go to a bank today, you make a promise, which is, of course, transformed into a contract, binding on you. You make a promise, if you receive cash from the bank, to buy a house, that you will every month repay that loan during 30 years. And if you die in the process, the great thing is that you pay an insurance company also for covering that risk. Okay, so, but you get cash today, and you can house your family today without waiting 30 years to accumulate the wealth. So it's a time machine, and it's a time machine which is socially useful to a large extent. The problem is that your promise is resold on the market time and time and time again, and created into derivatives that nobody knows what it really relates to anymore. But so as such, I would also like to maybe help the student think that through those instruments, there are some social needs that are met. Maybe there are other means to meet those social needs. Maybe the great way forward is to have public ownership of all the houses, and have a state system to allocate housing to people. But that's a big political debate. Now I come to my 2 points or questions. I have the impression, but please correct me, money is a way, and that is, I think, also deeply problematic existentially, but money is a way to escape the social. We have money, we can go to luxurious restaurants, and you know, the people, they go to McDonald's. We have money, we can go to luxury holidays places. We can go on yachts, we can go in nice villas. So there is, I think, and that's true, that's one of the functions of the money, and I strongly believe that's one of the reasons why people want to get rich, is because they want to escape from the social. And when you spoke, I had the impression that this human, which is maybe a bad human thing, but this possibility that money brings for some people is something that I think maybe that you do not address as such, but that as listening to you, that I probably think that you think is deeply problematic. And can you elaborate a little bit on that? I also think it is problematic because law is relational, basically. Law establishes the social, and at the same time, what you show through your unpacking of capitalism is that using law allows also to unravel the social and escape from it, which is quite paradoxical, but I think is a deep issue in your criticism of capitalism, maybe. And then my last point is to take your 4 key attributes of capital: priority, durability, convertibility, universality, and apply them to what my field of law. Stephanie's private international law, we have social law, the question of territorial sovereignty, public international law. If you take those 4 attributes and apply them to territorial sovereignty, there seems to me to be a perfect match. Priority, ranking claims about some assets. Well, the state has not only priority, but exclusivity. Durability, this is extending priority claims in time. And yes, the sovereign title on territory is eternal. States like to think of themselves as being eternal social constructs. Convertibility, the owner may freely transfer an asset, convert it into money. Well, if Ukraine wants to settle the war tomorrow, maybe they can give away a piece of land in exchange of 30 years of free gas from Russia. Convertibility. Universality extends priority claims in space. Yes, of course. It is universally opposable, this territorial title. So I think you're unpacking through those 4 attributes of capital are really opening eyes, at least as far as I'm concerned. But at the same time, I find them strangely also in a completely different setting, which is territorial sovereignty, state sovereignty. And of course, the only difference with capitalism there would be that instead of having a private owner, we have a public person, which is the state. But basically, fundamentally, the legal structure of what allows states to be what they are also can be described in those 4 terms. And so my question is, what is really the specificity then of those legal attributes? Thanks very much.
Okay, thank you very much, Pierre. I'm a bit hesitant to raise my own questions, given that it's 10 to 8. What I propose, Katharina, you have already a very good harvest of questions, I think, extremely interesting. Why don't you respond? And then I will follow up with questions that will gradually and almost seamlessly turn to the questions of students.
Okay, that sounds good. Thank you so much. Thank you so much for engaging with my work and for these wonderful questions. So I just will take them in the order in which they were raised. The first one by Julie, basically the fundamental questions is what happened actually since I published the book in 2019? Have any of the measures that I suggested been pushed forward or perhaps not? But of course, and so this is deeply related to the paradox that you identified. What is the role of the state? Is it complicit? Or is it basically, does it find itself in a situation where it has lost control over something and can no longer direct? And the second question is, what is the role of civil society actors? And these are all fundamentally important questions. So my approach, what I basically argue in the final chapter of the book, which I did not present, is that one could actually recode the system. If it's all done in social construct, if it's all done through legal means, one can also recode. But it's much more complicated than we think. You can't just say, oh yes, we'll just recode everything, because so many expectations, so much wealth, so many resources have been built in the system that we have, deeply entrenched in the way people think about the law, use the law, that you can't just switch it back to something else. So you have to think strategically, where are the soft spots where we could actually make some inroads in changing the system and creating a process of transformative change that will necessarily take a long period of time. So then the question, I would then reformulate the question and saying not something fundamentally has changed, but do we see inroads? Do we see some, hopes, signs of hope that something might be changing? And I do think, and Stephanie said this as well, you can see evidence on either side. So I don't think there's a clear sense in a particular direction. Not even in the face of the threats of climate change, where you would think that at some point people would get together and think, what can we actually do to slow down the system of running the entire system against the brick wall, because climate change, the problem with nature, that's the difference between social system and natural system. Capitalism assumes that it can always expand. You just find new assets. You start with land, then you do finance, and you do intellectual property rights, you do data. There will always be a new asset that you can grow rich on. And so social systems expand, and eat up the resources of nature to be able to do so. Nature will be less forgiving. It's a natural system. It has natural boundaries. And so it's kind of fighting back on us. But even in the face of that, we don't see actually many more reforms than I would have hoped for. I still don't believe we can just turn a switch and change the system. It has to be incremental, and we have to find the right entry points. So what has happened? There's some pushback. I think the EU is, I would say the EU is always like 25 years behind the US, so they're still doing the neoliberal stuff, as in the US. Somehow, some people are trying to push back, although the election results suggest not necessarily the majority. So I think there are some signs of hope. I think there has been some work in the space of bilateral investment treaties and state-investor disputes where countries have rewritten some of their treaties and are fighting back, basically being subjected to private power on the same scale that they used to be before. And that's, of course, led by a country like the United States, which initiated the whole movement towards these bilateral investment treaties and then found itself caught in the traps of it at some point. I do think that the OECD minimum tax for digital companies, which was extended to other corporations as well, is a good example of how international collaboration can still work. It's difficult, right? So Trump did not want to agree to this. It's the French who said that we will tax your tech company. We already have the law in place. We will tax these guys. And it's under that pressure because not only France, but then a dozen or so, or 24 other countries said, we will do the same. We just follow France's example. We have a different tax and different tax regime for these digital companies, the big tech companies, in all our jurisdictions. That's when the big tech companies told Trump, you can't do this. That's too costly. You want to have one regime, not many. And so the compromise, we basically said 12%, which is not very much tax, but at least it's a uniform regime, kind of uniform regime. Still has to be implemented. That's how progress is made, right? But it's not huge steps, right? You really have to fight hard to get there. I see other examples. Many of you might have followed the Royal Dutch Shell litigation by human rights activists about pollution in Nigeria, where they're basically doing what capital has always done. You just recode, you reinterpret existing law. And if you have heard corporate law, if you're familiar with corporate law, you will know that for corporations, they give their shareholders limited liability. So if a company runs out of money to pay its debt or to pay damages to people that they have basically damaged in a major way, they just go into bankruptcy. But the shareholders will never have to put money into it. Neither does a parent necessarily have to pay for the subsidiary. And the UK Supreme Court basically said we're basically not respecting the formality of two corporate entities between a Nigerian subsidiary that had polluted the waters of fishermen and the parent company now in the UK. We're actually saying the parent company owes a duty of care, like old agency law. We're not doing piercing the corporate veil, which is very hard. We're just going back to old basic principles of agency law, where a principal is responsible for tort committed by its agent if it controls the actions of that agent. So here's an example where we actually can use existing law and fight back against entrenched principles of corporate separateness, which I don't know why it had held so long, but it's an example for how we can push back. Of course, the corporations are pushing back as well, right? But it's an ingenious, I think, move, and I think one could show more examples like that. What is the role of NGOs? I think one of the fundamental shifts that we have to come to if we want to solve especially climate change, but also our political estrangement and the fractionalization of our societies. We have to shift from this extreme individualism back to cooperation. And I think existing organizations, including labor unions, are examples for ways in which people can associate and organize themselves around a cause. And that in and of itself is an important way, because that does create trust, not only within the organizations, but comparative and historical research suggests that it also has spillover effects on creating trust beyond those people that you know immediately. I think we need to have many more grassroots organizations that are organized around cause and trying to push the envelope in a little bit, just a little bit. So, no revolution. I don't believe in revolutions, but I do believe in incremental and yet transformative change, and I think they play an important role. Stephanie, conflict of laws. Yes, yes, I see the EU also backtracking further. As I said, I think it's just unfortunately that they kind of are always a little behind the curve. It takes ages and ages to come to final decisions in the EU, and by that time, I think the public discourse has already moved on. They're still sort of doing the final thing in Brussels to sign the stuff. Legal certainty. I think I'm an opponent of legal certainty. Whenever the financial sector always wants legal certainty. The big guys always want legal certainty. They're always screaming for legal certainty. But who then carries the legal uncertainty? It's the rest of society, right? We grant legal certainty to financial institutions to create these fancy assets, to create a global market for derivatives, always on the basis of legal certainty. That's why they needed the exemptions from bankruptcy to be able to enforce their contracts. And country after country after country after country conceded that. And what happened when the crisis came? All the derivatives went belly up first, right? So we believe these lies, to be frank. We believe these stories and grant them legal certainty because it's, of course, also a big legal principle. Max Weber talked about the importance of legal certainty and previsibility. But he said that's important for capitalism. He was right. They want to have predictability as much as they can. There are enough uncertainties, enough risks that they take, and if they know they can enforce somewhere, ideally in a court or arbitral tribunal that they have chosen, then they're fine. Everything else doesn't really matter, right? And so I think granting them this legal certainty basically creates the highway for the kind of products that they wish to create. And I think it's always a balancing act. I'm not saying take all the legal certainty away, but we need more sands in the mills of capital. And we need more legal certainty and social certainty for everybody else. Because the fragility of our financial system is borne out by society at large, not by capital. That will be bailed out. Because if capital, you've seen this in the 2008 crisis, you saw this with Silicon Valley Bank. in 23, is whenever there's a threat to the system, the central banks will jump and the treasuries, the finance ministers will jump and protect the systems, right? If homeowners are evicted, then it's their fault because they couldn't pay their loan, right? So we evict the small guys because they're not important for the system. Important for the system are the pillars of the system, and to them we always grant legal certainty, and I think that's part of the problem as I see it. So I think we need less legal certainty, and I think, you know, David Kennedy is of course correct that lawyers also make a lot of money on legal uncertainty, but there's a level of legal uncertainty that you can't purge from the system, right? Law is inherently incomplete, so it has to be reinterpreted all the time. That's what lawyers do. That's why they're helpful. You have frictions between different legal layers of legal systems within federations, within the EU, at the global systems. At each of these frictions, you make tons of money by knowing how to exploit this law versus the other. We can't get rid of that. So I think in that sense, both are true. There's always uncertainty and incompleteness in the legal system. That's helpful for lawyers. But for certain things where, when you see, especially financial entities, but others, lobbying for legal certainty, you know that's definitely sort of, you're shifting the bias in favor of those who want to code capital and know how to do this. And that brings me, of course, to social law. And I love the description of social law being like an emancipation from private law. It's the collective, yes. It's the collective, but I'm also always reminded of a quote from a book by Jonathan Levy, a historian in the United States, who wrote a book about ages of American capitalism. And he said in one chapter, laconically, he said, capitalism was there first, and then came democracy. Capitalism was there first. It's always there first. And then came democracy, and democracy did not take on capitalism, it embraced it. And in that sense, and this going back to your point, the state actively supported, is complicit in that system, and yes, has also lost control, but that should not diminish, I think, our understanding that it's deeply complicit in that system nonetheless. And yes, of course, and sort of the Bismarck reforms of the late 19th century are the best example. You do social protection and pension systems to make sure that the laborers don't go with the communists, but that they stay, you know, in the middle of the political system. Then you mobilize them for national interests like World War I and things like that. So that's an old trick in a way. But I think it's really important to realize the extent to which institutions of private law are very often used also as a weapon against the weaker, very often. So for me, one of the most striking things is in the United States, after emancipation, the 14th Amendment was enacted, which gave all persons who owned property a right to bring their cases to a federal court, because they knew they couldn't trust the state courts in the southern states, that the black people who might have some property at some point might protect it in a court of law. You could not trust the courts in the South, so you have a federal claim. In 1930, you get a Supreme Court decision where the dissenting Justice Black says, this amendment has used, in all the cases that we've seen that have been filed in federal courts, 0.5% have been brought by black people, by the former slaves. 50% have been brought by corporations that have expanded their own property rights. That's how you see how you can use the law if you have the resources to code your own interests. It's hugely powerful, and I think that's happening a lot. So what transformation in the law would create more autonomous labor? I don't think there's a single legal trick. I think what I would lobby for, or argue for, is that we need a much stronger move towards cooperation. And that might have to take the detour of empowering individuals to actually claim rights against other private entities. We have this really weird system of two systems, private and public, where we have claims against the state because only the state seems to be having power, right? And everything else is horizontal. We all have equal rights under the law because we do contractual relations and have property rights, and it's a little bit hierarchical, but at least, you know, if it's within that framework, that's all fine. But we don't have means for powerless people to make powerful claims, well-resourced, powerful claims against private actors. We don't have systems of accountability and control, and I think that's where we have to go. It's like the fishermen against Royal Dutch Shell. You are the principal of your subsidiary, that's your agent, we attribute that harm to you. And you have to compensate us. We have a right to live the lives that we have reason to value. If to quote the capabilities approach of Sen and Nussbaum, you have to give us the resources. Society at large, not just a state. The state is just a construct, like everything else the state. And now I want to say a word about women, then I'm moving on to Pierre's comments. What about exploitation of bodies? That has been a central part of capitalism, black bodies and female bodies and other bodies as well, labor bodies in many ways. I consider this to be part of the, primitive accumulation phase, but we have it to this day. I think where I just depart from a classic Marxist analysis is I'm basically saying we can't only find the sources of the capitalist regime in the classic relations of exploitations, even though they exist. But I think when we're always trying to find that sort of exploitation of labor, we are missing a bigger picture. And what I'm trying to say is what capital is really doing, it's exploiting two important social resources, our legal system and our money system. Neither of which can exist if people don't trust it. And on the basis of that trust, some can game the system better than others. So what does this mean for bodies? I mean, you can see that actually legal protections can make a huge difference in the life of people, women in particular, women's rights, rights to abortion. The backlash in the United States currently is ferocious. Right? So the kind of legislation that has been adopted in the southern states and many others that make it impossible for a woman to get care, even if they have a miscarriage, that's where you can see how the law turns around and makes women the victims again of their own bodies in a system in the 21st century America. So yes, it's still there. It's deep cultural sentiments, deep misogyny, in my opinion. It's now realized again by the law. And you see, and the legislators are mostly white men, I hate to say, but that's the world that we live in. But the law plays a critical role in manifesting, entrenching, and recreating these kind of power relations that we had thought we had overcome, but we're back there. Then finally to Pierre. Yes, money is a way to escape the social, but also particular, it has become that. Of course it has become that. That's a product of capitalism. I'm not sure it's necessarily in human nature. There are different ways in which we can think of human nature. And the one thing I also want to make clear, I spent the first 10 years of my academic life studying Russia and the former socialist system during privatization after. I'm not a fan of the old socialist system, but I also reject the idea that this is the only alternative that there is. I think there are many, many more different possibilities. And so the question is not whether we have only social housing. The question is what kind of housing can we create where people have control over their life, also the kind of housing that they want to have, without being exploited by international real estate conglomerates like BlackRock that are trying to raise the prices of the big housing complexes that they bought on the cheap in Berlin from the social democratic government, right? I mean, such a policy failure that they did this, but people are fighting back. There's so many examples. You can go to people at NGOs in San Francisco that are trying to create cooperative forms of housing. You can look at Germany in the 1920s building housing systems that had survived for decades and decades and decades until the social democratic government of Berlin sold it. That actually worked. They were pretty high quality housing and that worked. Vienna is of course the poster child for decent housing today. So people want to get rich, but the fact that that's the only purpose in life is a product of late capitalism. Of course, we have sort of the process of human evolution. Max Weber describes this wonderfully, sort of the credit contract becoming a purpose contract disembedded from social relations. It's a long story, but it's not an inevitable story. And we don't have to bring it to a point where the only thing that everybody is drilled, the only purpose for a corporation is shareholder value maximization. It doesn't mean what you produce, how you pollute, how you treat your labor. Nothing matters. I mean, the best example that I always like to use in this context is Boeing, American airplane corporation, where after the several MAX crashes, shareholders sued the company in a derivative action because they wanted to have the money paid back to the company that the directors had squandered by not monitoring the company. It turned out that Boeing had an audit committee to make sure that finances were safe. It did not have a safety committee to make sure that planes were safe. And so the chancellor in Delaware simply said, you know, if you produce planes, if that's your mission in life, planes have to fly. And that we have come to a point where we don't even think about the products that are being produced, but we're thinking only about shareholder value maximization and money, 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 just shows us, I think, the deprivation of the system. Last thing I want to say, I like the fact that you have used my attributes to apply it to sovereign states. There's, of course, a famous article by Morris Cohen from 1927 who talks about sovereignty and property and describes the two. So my critique of the system that we have is that we have private power wielders that are actually sovereigns, and they're piggybacking on our money and on our legal system. We still pretend that we're democracies. That's the problem.
Okay, so Katharina, three questions perhaps, and as I said, I will refer also to the comments I received from students in advance of this session. First, I was wondering whether you could comment on whether it is the quest for growth, by which I mean GDP increase, that explains the complicity of the state in the coding of capital and the protection it provides to property rights. Governments are still largely rated by the media, by public opinion, by rating agencies, financial markets, based on whether they manage to increase monetary wealth. Mm-hmm. And it seems to me that that makes them very much hostage to corporations, investors that they want to retain or to attract. They fear to lose out if other states become more attractive to these same investors. And so is this, in your view, at the heart of the problem of states that are at the same time complicit in the coding of capital and apparently powerless to interrupt the process? That's the first question. And by the way, this is my gift to you, because that's actually what the book tries to argue. The second question is, turning to alternatives. We have witnessed in the past 10 years a re-emergence of a debate on the commons, right? The beyond the enclosures that we've witnessed, and part of the book Governing Access to Essential Resources was about that. Is this a counter-movement to what you describe? Can the commons, understood as democratically managed resources that are controlled by the users themselves, rather than by a state bureaucracy or private markets, is this an alternative? And if so, under which conditions can this alternative be expanded further? And then my third question, perhaps, or comment, is that in the Machiavellian tradition I was describing earlier, in which the state is sort of deconstructed as the result of power relationships and competing influences, we have a left progressive version and a right conservative version. The left progressive says we must denounce the capture of the state by big corporations that are too big to fail, as John Kenneth Galbraith was already arguing, and that managed to convert their economic influence into political might. That's the left version. And then the right version is, we cannot trust the state. Public choice theory is espousing that vein, and you cite Charles Tilly, Manker Olson. There are also, George Stigler, and of course James Buchanan and Gordon Tullock. So we cannot trust the state to achieve social justice because the state is captured, and so we must perhaps trust others better, and including markets. And so the question is there a risk that the left critique of the state's impotence will backlash, creating the distrust in the ability of the state to make a difference, leading to depoliticization or to the rise of populist movements? And then, if democratizing the state is not sufficient or doomed to fail, should we not democratize society? to ensure that markets and corporations are held directly accountable and that markets become more participatory. And this is where I asked students to provide comments on the proposal of Christopher Menke to repoliticize economic and social life, to ensure people are empowered rather than a narrow elite monopolizing power through the use of property rights. And I received a range of proposals, some proposing to democratize politics, some proposing to democratize the economy. Julien Lebrun, emphasizing the role of social and solidarity economy, Maximilien Glasener, to redefine property rights to ensure they contribute to a social function. Sephirin Arnould, emphasizing the potential of community management of essential resources. Some have referred to democratizing work, ensuring that workers have a greater say in corporations beyond Mitbestimmung, a real, bicameral approach as advocated here by Isabel Ferreras. There are also students who said we should provide more incentives to ensure that jurists serve social organizations, social justice, rather than the economic elites. One student has advocated for unconditional basic income, Adelaide van den Ouwera. And I would like to close with two students who made very contrasting proposals linked to what I would like to call perfecting the markets. Some proposals, indeed, were basically premised on the idea that we should make markets more perfect, ensuring that markets are organized in a way that resembles what we find in economics textbooks. In the neoliberal tradition of developing and promoting and strengthening property rights, so that markets look more like perfectly rational agents, well-informed, that are price takers, and look less like markets captured by some grand corporations that control the rules of the game. And it is striking that when FDR, Franklin Delano Roosevelt, launched his second New Deal starting in 1936, it was actually a lot about ensuring that markets work well by a very strong competition policy in the hands of Thurman Arnold, to make sure that markets would look like what the idealized markets of economists should resemble. And we have in the legal theory course Theo Carlier, who argues for the role of competition law in breaking down monopolies and ensuring that markets are truly competitive, where others, including Adrien Gilbeault, whom I would like to cite also, say markets necessarily will function as an auctioning process in which the wealthiest will win the game ultimately. Markets are plutocracies, they register demand, and ultimately the resources will be captured by those who can put more money on the table. And so it makes no sense to make markets function better. We need to provide alternatives to markets. So I'm sorry, this is a bit disorderly, but I wanted to, at the very least, pay tribute to some of the students who provided comments in preparation of this session. And of course, dear students, if you feel you want to make more explicit what you said, especially those whom I cited, or if you want to add additional questions, now is your last chance to do so. But maybe you should first react.
I should first react, and they can think. Okay, so I'll try to again go through the order. So the quest for growth, I think, plays an important role, especially because most governments, most democratically elected governments, have now said they have basically tied their hands to growth. I mean, growth is not a bad thing. I think you might also, in order to have employment for everybody, you need some level of growth, especially if the employment sector is growing. I have to say I was puzzled reading the Draghi report for the EU Commission when he said, in Europe, sort of the gap to the US is widening so much, but in part is because demographic change. So if basically the population declines, then maybe it's also normal that we don't have quite as much growth. So you have to look at per capita growth, not aggregate levels of growth. But I think it has become a mantra. It's growth and it's the stock markets, maybe sometimes, rather than. So what I'm saying is, I'm not arguing fundamentally against growth. I do read some of the degrowth literature, and I think we have to limit the expansion of the social systems given our natural constraints. But I think the problem is that we have made growth basically the primary way by which we judge our leaders. In the US, maybe more extreme than elsewhere, but I think it has also spilled over to Europe. And I think this has, as you suggest, makes governments hostage to those who are allegedly producing the growth, where they're not actually doing it, but they have the means to do it. And so they're basically tooting into their horns. So I agree that's really a problem. The debate over the commons, yes, I mean, I think, this planet is kind of our commons, and we all depend on it for our survival, so we should better take care of it. Space around us, the space is actually treated in international law as the commons, and yet Elon Musk, of course, is shooting as many satellites into it as he wishes, and the Americans have passed a law that says if you bring stuff back from the space onto the territory of the United States, we grant you property rights. So no property rights in space, but you bring it back here, you get property rights, right? Luxembourg also. So that's a fundamental violation of principles of the commons, and they're very hard to fight because they have lots of resources, and as you know, Elon Musk is now sitting basically in the White House as well. So I think there are, at the same time, many movements, and I'm also talking to many people who are trying to push the ship in a different direction. I think that's what we have to do. We have to find alternative solutions now and work on them. And as we actually are living through highly uncertain times, and uncertainty increases and the system becomes more volatile, we also see opportunities, I think, to push the system further. So I think there are many organizations that are trying to protect the planet. There are people I talk to who have read the Code of Capital. They want to do the recoding. They want to change and are finding ways in which they can repurpose the law for different ends. I think this is positive. There is hope to some extent, but it's especially with there is not a basic understanding that we should treat at least nature as a commons, right? I think it's not there yet, and we try to push for this and saying actually water should not be priced because it can't be that water is basically given only to those who can pay most money. That's the auction system. So certain things should not be subject to the pricing principle because the price knows only one thing, up or down, doesn't know anything else. It's not a good way to govern complex relations, and I think the commons is such an example. But not everybody respects the idea of a commons, of a genetic code, of space, of water as being a commons. But I think we have no choice but to continue to push for that normatively. I think it's a fundamental normative debate that has to then, of course, rein in property rights and other claims. And now, of course, this is the students ask great questions, so thank you for that. Yes, we can either perfect the market or we can't. But it's always failing us. As I just suggested, the market can do certain things really well. If it's only a question of pricing something against something that is very similar, the market is very good at this, provided there's enough information about the two things that we're pricing out there. So if we have sufficient amount of public information, then you can at least assume that there's some efficiency in the system. It's never super strong, but some efficiencies in the system. The price mechanism says, you pay more for this, somebody pays a little bit more, probably has more value for this good, and so you allocate the good in this way. The problem, of course, is that the market can't solve our social problems. It can't solve climate change. These are far too complex problems. It has only this one dumb thing, price up, price down, and then you just do the auction process. But when you do multiple auctions for every little social goal or good that we have, somebody has to reconcile how to set priorities. What is really essential today? Is it actually growth? Or is it sort of dealing with the problems of climate change? That the market won't do. And to the contrary, the market now prices oil and gas assets really high because Trump came back into power and says they can drill. And so people are making tons of money on something that we know will destroy our climate, is already destroying our climate. So the market doesn't understand that it is amoral. And the most amoral of all systems is the market. So I think I won't trust the market for more than just pricing some assets that we can sort of trade. That's fine, but not for basic big social problems and big social issues. So I think agree with the second student to say it's an auction process, necessarily. More markets cannot do. And so we have to find other forms of social organization. So one of the most striking things for me is that people no longer talk really about the importance of organizations, whether these are companies or associations or the state as an organization. So companies in the economics literature are described as a nexus of contracts. It's all bilateral contract, and it's all that. And so I think one has to ask the question, what is it that organizations can do that markets cannot? And how can we mobilize organizations, civil society organizations, private organizations, and the state as an organization, not as an auctioneer, for the purposes that we have to commit ourselves to?
Mm-hmm. Thank you, Katharina. Maybe in one of your future books, you will use the word organocene, just like we speak about the Anthropocene. Because I think many decisions are taken today not by individuals based on their own sense of morality or ethics, but they are taken by organizations in which we operate, and that is, the banality of evil, as described by Hannah Arendt. Many decisions that matter in our everyday lives are taken by organizations who have a logic of their own, which no one anymore masters, and sometimes no one understands. And I think we have to, we may have to work more on how social logic is less and less under the control of individuals with their own sense of morality, and more in the control of these mega machines, these organizations that we are just pawns for, right, and
yes.
instruments of.
And that are portrayed as individuals,
right?
It's the individual property rights of a corporation. It's the corporation that acts as a legal person, even though it's a huge bureaucracy and it's actually collective. But so yes,
it's a fictitious legal person, and there was, I forgot the title of the documentary, but a psychologist who looked at how corporations operate based on the fiduciary duty to maximize shareholder value, and the conclusion of this psychologist was corporations are psychopaths. And so giving them all this power in society is like, releasing from jail dozens, thousands of psychopaths with enormous power they can yield in society. Right. Well, I'm not sure this is a very optimistic note on which to close, but I'd like to thank you all for your presence. Thank my colleagues, Pascal, Stéphanie, Pierre, Julie, for their contributions. Katharina will intervene tomorrow at the European Law Seminar, and then she'll be at the European Economic and Social Committee later, and then on Thursday you will be in a master's class that Annelise Sibony, I think with Pascal or with Isabelle Ferreras will be leading, right? But anyway, thank you so much, Katharina, for your contribution.
Thank you.